Hi, my name is Duffy Carolan. I'm an attorney at Davis, Wright, Tremaine in San Francisco, California. And we're going to be talking about access to court records today, both state and federal court, although I'll be focusing more on state court. We're going to be talking about where your rights come from, the tests that courts apply for access to court records, and the various legal standards applied. Then I'm going to take you through a case, a civil case and a criminal case. We'll start with the criminal case from beginning to end and touch upon the kinds of access issues that typically arise throughout a case from beginning to end, with the general idea being that by the end of the presentation you'll have a good idea of when your rights may be deprived and when to stand up and say something about it. So your rights come from three basic areas. First and foremost is the Constitution, the First Amendment of the United States Constitution and Article 1, Section 2 of the California Constitution. It's not expressly set forth in the First Amendment or the California Constitution that you have a right of access to court records or court proceedings, but courts have said that it's implicit in those constitutional rights that you have an access to court proceedings, and other courts have found that that right of access to court proceedings extends to court documents and court records as well. And then there's a common law right of access. And a common law right of access stems from case law, case authority that has been handed down by courts and is binding on jurisdictions within those court jurisdictions, or persuasive of courts outside of a particular jurisdiction. And then you have statutory law. Statutes, both in California and federal, under federal law, provide specific access rights to certain types of documents and certain types of proceedings. And these areas of access are important in the sense that there are different standards that will be applied if the right emanates from a First Amendment right of access as opposed to a common law right of access. The right of access under the First Amendment tends to be a stricter test that the courts apply before they will bar the public from any proceeding or seal any court record, as opposed to, for example, the common law right. And then the statutory rights of access may provide a right of access that you wouldn't otherwise have under the Constitution. So knowing where your rights of access come from can be important in certain circumstances. The test for whether or not there is a First Amendment right of access has emanated from the United States Supreme Court decision in 1980, Richmond Newspapers versus Virginia. And it is a two-part test that has been applied from that case forward in determining whether there is a First Amendment right of access to a particular proceeding, and courts have also used the same test to determine whether there's a right of access to court records. And first part of the test looks at whether there's a history of access to the particular proceeding. And you can go back even to English law to determine whether or not something has historically been open and accessible to the public or not. And then the second part of the test looks at what the functional utility of access is, whether or not an open proceeding will fulfill what access is intended to fulfill, which, as courts have recognized, it is to enhance the fairness of the proceeding and discourage perjury and misconduct during the proceedings. By the sheer fact that they're open to the public, that scrutiny enhances those processes. It also provides a therapeutic or prophylactic value in certain types of cases, certainly ones that are, for example, shocking to communities. To be able to see these issues resolved in an open and public manner provides that kind of therapeutic value. So courts have recognized a number of reasons why particular proceedings or particular access to particular documents should be open. And in determining whether or not there is a First Amendment rights, they apply that two-part test, first looking at the history and then looking at the functional utility of a particular proceeding, whether opening up that proceeding or providing access to that particular document will fulfill what the courts consider to be the important principles behind open proceedings. The requirements to close a proceeding or to seal any particular document have both a procedural and a substantive components. And in California, the leading case is NBC Subsidiary versus Superior Court. It was a civil case where it involved Clint Eastwood and Sandra Locke in a very high-profile breach of fiduciary duty contract action. And in that case, for the first time, the California Supreme Court determined that there was a First Amendment right not only to criminal proceedings, which the United States Supreme Court had long recognized before NBC Subsidiary, but also to civil proceedings in this state. And other cases, other states have followed suit as well. But once there is an established First Amendment right under the two-part test, then the courts determine, then the courts are required to follow a two-part analysis, one that provides for procedural components that a court must follow before sealing any court record or closing any proceeding, and substantive procedures. The procedural components that a court must follow are notice to the public of the contemplated closure of a proceeding or sealing of a document. And the quantity of the notice, the quality of the notice, I should say, really depends on when in the proceeding the request for closure transpires. If it's during a trial, for example, notice by the court by announcing it on the record may be sufficient. If it's a request to close or to seal certain documents, it may be more appropriate for the court to put notice forth on the public dockets. What's not required is notice expressly to the press or to specific individuals. Once there is a First Amendment right of access determined in the two-part test, courts then have to apply an analysis that includes both a procedural component and a substantive component. Procedural component meaning what a court must do before any court proceeding or a court document can be sealed. And that is a three-part process where the court must provide notice of the contemplated closure or sealing of a particular document. And the quality of the notice will depend on where in the proceeding the request for closure takes place. For example, if it's during a trial, it may be enough for the court just to announce in the open record that there is going to be a hearing of a contemplated closure. But if it's a request to seal records, for example, prior to a trial, then the request should should be made on the open documents with a noticed motion. So the notice would be through the court dockets. What's not required is notice to people, third parties to a particular action. There's no requirement that particular individuals or the press be provided notice of a closure. You have to look at the court documents and you have to keep your ears open during proceedings to hear if there's going to be any closure issues. Then the court must hold a hearing on the contemplated closure where people may be able to express their views of that closure. And in that hearing or after, the court has to make express findings supporting the determination, if there is a determination to close particular proceedings. These standards were articulated in United States Supreme Court authority involving criminal cases, and then in 1999 adopted in one of the leading cases in California, applying the First Amendment right of access to civil proceedings before the United States Supreme Court had applied the First Amendment right of access to criminal proceedings. So NBC Subsidiary versus Superior Court, which involved a high-profile case involving Clint Eastwood and Sandra Locke, a breach of fiduciary duty case, was the first case in California to determine that the First Amendment right of access applied to civil cases as well as criminal cases. So in addition to the procedural components that a court must go through before there is any closure or sealing of a document, then the court must consider the substantive components of closure. And in order to seal a document or close a proceeding, there has to be, first and foremost, an overriding interest that supports the sealing or closure. Most cases involve a defendant's fair trial rights. Some cases involve trade secrets or individual privacy rights. For example, minor victims who are called to testify in sex crime cases. But these interests standing alone are not sufficient to close a trial or to seal particular documents. You have to look at the particular facts in a case, and in particular with a criminal defendant's fair trial rights. Even in very high-profile cases, that does not necessarily mean that a trial can be closed or certain portions of a trial can be closed. The prejudice that a defendant must point to in order to close a trial really has to be to the degree that it would be very difficult for the judge to find and the parties to find an impartial jury in that jurisdiction. So the size, for example, of the city that the juror is sitting will definitely play a part in that determination. If you're in a large metropolitan area, you have a large jury pool, very, very difficult to prove that there's going to be a prejudicial effect from disclosure of a certain record in a criminal trial, for example. Then the second component, there has to be a substantial probability of prejudice absent the closure or absent the sealing. Again, it's not a reasonable likelihood, it's not guesswork. There has to be a substantial probability of prejudice. Then, if there is going to be a closure or a sealing, the sealing has to be narrowly tailored to direct and cover the interest that is at issue. For example, if you can prevent prejudice to the defendant by excising certain portions of a record and producing the rest to the public, then that's what should be done. It shouldn't be a wholesale closure to prevent a prejudice. It has to be narrowly tailored. And then there has to be no less restrictive means to achieve the goal of protecting the interest. For example, if the prejudice can be prevented by constant admonitions to the jury throughout the trial that they shouldn't be watching trial publicity, for example, or that their determination should be made only on the evidence that's submitted in trial, then that's what the court should do, as opposed to sealing evidence or preventing the public from attending. Also, jury instructions. Anyone who sat on a jury knows that jurors take their call very seriously. Jury instructions that remind the jury that they are not to make their determinations based on anything outside of the courtroom, any pre-trial or trial publicity, only on the evidence is certainly a measure that the court must consider, in addition to measures such as potentially sequestering a jury from publicity during a trial, and perhaps moving the jury to a change of venue. The California Rules of Court track the requirements of the NBC case and were adopted soon after the NBC case and govern the requirements that a party must go through before requesting that a document be sealed in California courts. The California Rules of Court provide for a presumption of access to all court records unless confidentiality is otherwise required by law. Certain proceedings, such as family proceedings, mental health proceedings, are required by law to be confidential, but for the most part, these rules apply to civil and criminal cases alike. And like the standard set out in the NBC subsidiary case to seal a record, now the California Rules of Court require that there be a noticed motion before a document can be sealed. And in support of that motion, the party that's requesting that a document be sealed must lodge with the court the document that it wants to be sealed, or the portions of the record that it wants to be sealed, and then it has to file a redacted version in the court for the court's determination. And then there must be a motion and a hearing so that the public, if they're informed through the public dockets that there's going to be a contemplated closure hearing, can have the opportunity to attend. Now, the substantive requirements that a court must apply in determining whether there should be a sealing over a particular document, very similar to the NBC case. An overriding interest must exist, a substantial probability that the interest will be prejudiced, a narrowly tailored order to protect the interest, and no less restrictive means exist that could protect the interest short of the sealing. So very similar test as that set forth in the NBC case. So in federal courts, it's a very similar test as that set forth by the California Supreme Court and NBC subsidiary. There's a notice, a hearing, and a showing must be made that the sealing is strictly and inescapably necessary to protect the fair trial guarantee of a criminal defendant, for example. So it's a very similar showing as required under California law. Now I'm going to take you through kind of the beginning to the end of a criminal case, and then we'll go to a civil case, touching on the kind of main access issues that you may encounter in a criminal case and then a civil case. Starting from the beginning, grand jury transcripts in a criminal case. Under state law, grand jury transcripts are accessible to the public 10 days after they have been provided to a criminal defense attorney. And that's a statutory right, Penal Code Section 938.1. The grand jury proceedings themselves are confidential. There's no right of access to the grand jury proceedings themselves. There is also watchdog functions that grand jurors serve, and there is no public right of access to the documents or to the proceedings of the grand jury when they serve in that watchdog function. Federal law, however, there is no right of access to grand jury transcripts or grand jury proceedings unless the grand jury transcripts are subsequently introduced at a trial or in a criminal proceeding for some other purpose. But there's no right of access like there is under California law, where you have a penal code that provides for the right of access 10 days after the documents have been delivered, the transcripts have been delivered to a criminal defense counsel. Information and indictments, those are generally the documents that start a criminal proceeding. Those are presumptively open to the public once they're filed. search warrants and supporting documents, the kind of documents that are generated in executing a search warrant would be a court's order showing probable cause for issuing a search warrant, a police officer affidavit showing probable cause, and once the search warrant is executed, a return indexing the items that were seized. All this information is accessible under California law, under Penal Code 1534C, following 10 days after issuance of the search warrant or its return, whichever is sooner. Videotapes, if they take place of the searches, are, or at least a court has held that they are not public, and the actual items seized are not publicly available. Okay, so court dockets I have listed here because it continues to be an issue, although not a prevalent one. Secret docketing happens in, we've heard of it happening in certain federal courts where there's a non-public docketing system for very limited and very rare cases where just the mere existence of the case can cause a risk perhaps of harm to those involved in the case, co-conspirators or witnesses. We've also unfortunately seen it happen in instances like search warrant returns, which should normally be filed with the court, are being maintained elsewhere, so they're never even part of the court record. It's just something to alert yourself to if you think, if you've heard, for example, of a search warrant that's been returned and you go to the local court and you can't find it, you may not be crazy. It just may be a matter of that hasn't become part of a court record, although it should be filed with the court and docketed and become accessible to the public. But just an issue to be aware of. Now still going through a criminal trial, preliminary hearing transcripts are presumptively open and have established case law that says there is a First Amendment right to preliminary hearing transcripts. Same with plea bargains. Very important since so many cases are actually resolved well before trial and plea out. Access to plea bargains has been held to be a First Amendment right, and under the facts of a particular case, there perhaps could be a closure or a sealing, but generally there is a right of access. Same with suppression hearings, when courts are determining what evidence is going to be introduced at trial, what will be allowed, what won't be allowed. Even though the information or the evidence is going to be excluded at trial, the public still has a right to participate in that process and see where courts are deciding what information should be allowed in a court proceeding and what information should not. That's a very important part of a criminal trial, and courts have held that there is a First Amendment right of access to suppression hearings. Psychiatric competency reports, that's a Kaczynski case. A few years back, there is a right of access, a presumptive right of access to that information, although you may not be able to get all of it depending on the circumstances of the case, but we have been able to get access to that type of information. Starting in the trial, the voir dire is presumptively open. The U.S. Supreme Court has so held, and questionnaires are also presumptively open to the public. In California, if the jurors are called to the juror box, then the questionnaires that are filled out and completed by that juror should be accessible to the public. Same in state court. The names and addresses of jurors and telephone numbers, the public has a right of access to that information, but that right is limited under California law because once a verdict is returned in a criminal case, that information is sealed. So it's really important for you to get access to that information during the criminal trial, because once a verdict comes in, then those documents will be sealed, and you'll have to make if you want access to that information, a showing of good cause on a motion with the court. So it's much easier to get access to that information while the proceedings are ongoing. During the trial, the transcripts that the court reporter transcribes the events of the day, and those transcripts are open to the public, as well as trial exhibits that are admitted during the criminal trial. If there are videotapes, the public has a right of access to the videotapes. If there are paper documents, the public has a right of access to those, unless there is going to be a showing made, as we discussed before, under the standards that courts must apply before sealing any document. But there's a presumption of access to trial exhibits, trial transcripts. I have sidebar and in-chambers conferences here because oftentimes you'll see courts taking the parties back into chambers and sidebar conversations during a trial. The important rule to remember is if there are substantive conversations taking place during those sidebar conferences or substantive conversations taking place during the in-chambers conferences, that the public has a presumptive right of access to those sidebar and in-chamber conferences, even though the access is impossible at the time. And in order to establish that there are substantive conversations taking place that should be open to the public, it would just be important to ask that the court or the clerk to access to the transcript of those proceedings. If they're not being transcribed by a court reporter, then ask if there is any minutes that are taking place that are recording the main decisions in those proceedings. But sidebar conversations or in-chambers conferences that are non-substantive, for example, dealing with scheduling issues or things that are not determinative of the trial, or I wouldn't say determinative, but issues that are going to be decided in the trial are fine, and the public has not had an historic right of access into the chambers for non-substantive conversations or issues. After a trial, there are pre-sentence investigation reports that may be generated, and courts have found that there is a presumptive right of access to pre-sentence investigation reports. Although in different federal jurisdictions there are different practices among the judges, so it may be that instead of publicly filing pre-sentence investigation reports, those documents are automatically filed under seal. So the clarity in the law with respect to pre-sentence investigation reports in the federal courts is not resolved. And in state court, you do have a presumptive right of access to pre-sentence investigation reports. Juror misconduct, and juror deliberations, there's no historical right of access to jury deliberations. That is a function that is private to enhance the deliberative process of the jury so they can feel free to discuss all the issues that are presented at trial. That doesn't mean, however, that if a juror misconduct leads to perhaps a motion to dismiss, that the motion to dismiss can't be made public with perhaps redaction for the misconduct issues. But traditionally, juror deliberations have been private. In support of sentencing, courts often hear from witnesses who provide statements to the court, either written statements or videotape statements that help the court decide what the proper sentence should be. A transcript of a victim's statement is public, but the statement itself is not public. So if a videotape, for example, is submitted by a witness, the videotape is not public, but the transcript that must be submitted to the court is available to the public. Juror qualifying information under federal law is accessible to the public. A lot of information about juror qualification, not a particular jury per se, but the entire pool that the federal court is pulling from is accessible by federal law. Now, going to civil actions, the pleadings and motions are presumptively open in civil actions. Discovery motions and related papers, there's no presumptive right of access, unfortunately, to discovery until the discovery is actually submitted to the court in conjunction with a motion or trial. Discovery is usually the process by which, or is the process by which the parties gather information from each other prior to a trial, and that has historically not been open to the public unless and until that information that is gathered is submitted in conjunction with the court proceeding. Trial exhibits and transcripts, again, there's a presumptive right of access to trial exhibits and transcripts in civil matters, just as there is in criminal matters. I wanted to make a note with respect to discovery motions and discovery materials. In federal court, there is a bit of a difference. If a court has entered a protective order, which is often requested during the discovery phase of a proceeding, if a court has made an entry of a protective order based on a showing of good cause, then the presumption of access that would normally apply is flipped, and the proponent of access now has to show a sufficient justification for access to discovery materials if a court has already made a determination of good cause. And this applies only to non-dispositive motions, and that means motions that are not going to resolve the case, for example, discovery motions. It would not apply to motions to dismiss or summary judgment motions or the trial itself, but to non-dispositive motion, if a court has already entered a good cause order for issuance of a protective order, the presumption is flipped in that particular instance. Finally, settlement agreements. That can be particularly problematic because most settlements transpire between parties without any involvement of the court, and in those cases, the public doesn't have a right of access to the settlement agreements. There is a right of access to settlement information if the parties dictate the terms in an open court proceeding or the terms are included in court documents. Then those terms are accessible as any other court record would be. But for the most part, the problem with access to settlement agreements is that the settlement agreements take place without involvement of the court and are not set forth on the court record. So there is no presumptive right of access in that case to settlement agreements, only if they are set forth on the record. If the settlement is with a public entity under California law, you would have a right of access, however, to the settlement agreement under the California Public Records Act. So an independent right of access, but it only applies to public agencies in California. If private settlements are included on the record, it's possible that they can be sealed, but just keep in mind that later on circumstances can change and there may be a right of access. The need for confidentiality may no longer exist a year or two down the road. So if there is a sealing of settlement agreements, don't necessarily give up. I included here some information on the California rules regarding electronic access. This does not preclude a court from sealing particular documents. But it's just to alert you to the fact that much information now in California courts is available on the internet, and it's available remotely with respect to register of actions, calendars and indexes of the court that describe the particular proceedings in the court that have taken place in a particular case. That is now available through the internet, through the court's website, as well as all the records in civil cases are now available remotely, or if you go to the courthouse, if they're maintained in electronic form, they're available to be reviewed in that form. With specific exceptions, the exceptions are set forth in the statute, particular family code proceedings, juvenile court proceedings are not accessible remotely, and actual criminal proceedings as well are not accessible remotely. You can't get the list of, you can't get the court documents submitted in a criminal case remotely in state court. In federal court, actually, there's a very big push to have the documents submitted in civil and criminal cases accessible, and that really will depend on your jurisdiction, but a lot of information of in court records is now available on the internet. So we've gone through a criminal and a civil trial from beginning to end, and these are just examples of the types of access issues that may arise during these cases. Certainly any individual case will have different issues that you can access, but hopefully the presentation gave you an idea of the tests that the courts will apply, the really high standards that must be met before any document can be sealed, and also gave you a good idea of when your rights may be infringed and when you should stand up and perhaps give you some, and perhaps provided you with some information to assert your rights in court. Thank you.